Companies Act Section 47, Voting Rights. 1. Voting rights of equity shareholders. General voting rights. Under Section 47 of the Companies Act, every member of a company limited by shares who holds equity share capital is endowed with the fundamental right to vote on every resolution presented before the company. This right is a cornerstone of corporate governance, facilitating shareholder participation in the decision-making processes that shape the direction and strategy of the company. Importance of voting rights. The ability to vote is crucial for equity shareholders as it empowers them to influence key corporate decisions, such as changes in company policies, approval of mergers and acquisitions, amendments to the company's Articles of Association, and the election of directors. The right to vote embodies the principles of shareholder democracy, ensuring that those who have invested in the company have a say in its operations and governance. This participatory mechanism fosters a sense of ownership and accountability, encouraging shareholders to engage actively in the corporate affairs of the company. Voting proportion. The voting rights of each member are intricately linked to their proportionate shareholding in the paid-up equity share capital of the company. This principle of proportionality serves to create a fair and equitable voting process. Proportional voting power. On a poll, each member's voting power is directly proportional to the number of equity shares they hold. For instance, a shareholder with a larger stake in the company, possessing a significant number of shares, will wield greater influence over corporate decisions than a shareholder with a smaller holding. This proportionality ensures that the voting power reflects the economic interests of the shareholders, allowing those with more significant investments to have a correspondingly greater voice in determining the company's future. Illustration of voting power. To illustrate, consider a company with a total paid-up equity share capital of 1 million shares. If a shareholder holds 100,000 shares, they would possess 10% of the voting power during a poll. This structure enables shareholders to have a direct stake in the outcome of resolutions, reinforcing the notion that their economic interests are aligned with their voting rights. 2. Voting rights of preference shareholders. Restricted voting rights. In contrast to equity shareholders, members holding preference share capital have limited voting rights. These rights are specifically constrained to certain resolutions that directly impact their interests. Specific resolutions for voting. Preference shareholders are entitled to vote only on resolutions that affect the rights attached to their preference shares. This includes resolutions such as changes to rights. Any proposed amendments to the rights associated with their preference shares, including alterations in dividend rates or terms of conversion. Winding up of the company. Preference shareholders have the right to vote on resolutions concerning the winding up of the company. This is essential as it safeguards their financial interests in a situation where the company may be dissolved or liquidated. Repayment or reduction of share capital. Additionally, preference shareholders can vote on resolutions related to the repayment or reduction of the company's equity or preference share capital. This ensures that their rights are protected in financial decisions that may affect their capital investment. Voting proportion. The voting rights of preference shareholders are determined by their shareholding in the paid-up preference share capital of the company. Proportional voting rights. On a poll, the voting rights of preference shareholders will be proportional to the number of preference shares they hold. However, it is important to note that the voting rights of preference shareholders are generally more restricted than those of equity shareholders. This distinction reflects the different roles and risk profiles associated with these classes of shares. Equity to preference ratio. The ratio of voting rights between equity shareholders and preference shareholders is designed to accurately reflect the ratio of the paid-up capital in equity shares to the paid-up capital in preference shares. This proportional representation ensures that all shareholders have a fair opportunity to express their views on matters that pertain to their investments. Voting rights for unpaid dividends. One significant protection for preference shareholders is established in cases where dividends on their shares remain unpaid for an extended period. Voting rights after 2 years. If dividends on a class of preference shares have not been paid for a period of 2 years or more, the holders of such preference shares are granted the right to vote on all resolutions presented before the company. This provision acts as a safeguard, ensuring that preference shareholders are not left without a voice in crucial decisions, particularly when their expected returns on investment have not been fulfilled. Purpose of this provision. By granting voting rights in this scenario, the legislation aims to protect the interests of preference shareholders, who may feel vulnerable due to the company's failure to meet its dividend obligations. This safeguard empowers preference shareholders to influence decisions during critical times when their financial interests are at risk, enhancing accountability and responsiveness from the company's management.